All right, I think we're going to get started in a moment, folks. Thank you. Good afternoon, and welcome to the investiture of Professor Lesley Wexler as the John D. Colombo Professor of Law. I'm the Dean of the Law School, Vic Amar, and it is wonderful to see so many friends, colleagues, and students here to celebrate this significant occasion. I want to especially recognize and welcome Lesley's father, Michael, for being here, and Lesley's mother, Rhonda Gashman, who couldn't be here in person but who is joining us virtually. Investitures are a long-established tradition in academia to acknowledge and honor faculty members who, over the course of their careers, have shown exemplary achievement in their scholarship, teaching, and public engagement. And investiture of a named professor honors the very highest level of accomplishment in those realms. In addition to celebrating our recipient and honoree and her family and friends, the investiture this afternoon affords us an opportunity to honor the donors whose vision and generosity make events like this possible, of course. The John D. Colombo Professorship in Law was established through an estate gift from June Evelyn Michael of St. Louis, Missouri. The gift funded this professorship and established need-based scholarships for students at the College of Law. Ms. Michael was born in Herrin, Illinois in 1921, and during her career, she worked for Bell Telephone, the FBI, and Washington University at St. Louis, where she also attended school. The gift that created this professorship was made in honor of her cousin, Professor John D. Colombo, the Albert E. Jenner Jr. Professor of Law Emeritus. John has been a pillar of the College of Law community for a long time. He served as Associate Dean of the College of Law from 1995 to 1998, again from 1999 to 2000, and again from 2010 to 2012. He was acting dean during 1998 and 2001, and interim dean from 2014 and 15. I'm not sure what the difference between acting and interim is, but that's above my pay grade. He also was the Thomas M. Mengler Faculty Scholar from 2004 to 2006. A valued member of the Illinois faculty since 1988 and a graduate of the College of Law. John continues, even in his emeritus part of his career, to teach tax law. He's the author of numerous scholarly articles on taxation and is a co-author of 2 books on the theory of tax exemption for charitable organizations, the exemption standards for nonprofit hospitals, and commercial activity by charities. We are indeed grateful to Ms. Michael for her generous estate gift, and honored that John and his wife Tina are joining us here today to celebrate Professor Wexler and her accomplishments. We're also joined today by some folks from our central campus. We have the Dean of the College of Liberal Arts and Sciences, Venetria Patton. Nice to see you, Dean Patton, who has been kind enough to attend a handful now of our investitures. And I think the linkages between LAS and the College of Law are extremely important, and we're really honored to have you here, Dean Patton. We also have my colleague, friend, and I recently learned, my neighbor, Ritu Mavokila, Vice Provost for International Affairs and Global Strategies. As the campus's Senior International Officer, Ritu is responsible for cultivating relationships with institutions around the world while bringing together the university's vast on-campus international presence. We, of course, have one of the largest number of international students and scholars of any university in the United States, and we've had a really rich tradition of that going back many, many decades. And Ritu is keeping that tradition alive and strong. Prior to coming back to Illinois to serve in her current role, she was the Assistant Dean for International Studies in the College of Education and a professor of higher education in the Department of Educational Administration at Michigan State University. Originally from South Africa, Ritu received her bachelor's degree in economics from Ohio Wesleyan, magna cum laude and Phi Beta Kappa, and her master's in labor in industrial relations, her master's in labor and industrial relations and her PhD in educational policy studies, both here from the Urbana campus, which is why I said she is coming back. A former Fulbright New Century Scholar, Ritu's research examines experiences of marginalized peoples and aims to inform institutional policies that affect these groups within institutions of higher education. She's devoted a significant part of her career to studying higher education issues in developing and transitional countries. She's the author, co-editor, or editor of 7 books and has published extensively in national and international journals. It's our honor to have her here today representing the Provost's office. So please join me in welcoming Ritu to the stage.
Good afternoon, and thank you, Vic, for that wonderful introduction. It is truly a pleasure to be here this afternoon celebrating one of our most distinguished faculty colleagues. Thank you, Dean Amar, for your remarks and your leadership here in the College of Law. As introduced, I'm truly honored to represent the Provost office to celebrate Dr. Lesley Wexler's investiture as the John D. Colombo Professor of Law. And on behalf of Provost Cangularis, I offer my congratulations to Dr. Wexler on this well-deserved recognition. Today, we are here to celebrate scholarship and education. Endowed professorships, as Dean Amar indicated, are one of the highest honors the university confers upon its faculty members. Our faculty are the intellectual heart of our institution, and through investitures, we recognize their innovation and contributions and express our gratitude for their impact. This investiture also presents us an opportunity to reflect on our shared vision and our shared purpose. As a land-grant university with a global impact, the university's mission is to serve our community locally, nationally, and internationally. As faculty members, we have unique responsibilities to engage in scholarship that addresses the issues within our society, while empowering our students to do the same and to be leaders in their respective academic fields. Professor Wexler's contributions meet these criteria. Not only is she an accomplished teacher, but her research has addressed human rights challenges and explored how discrimination impacts our legal system, as well as advocated for the rights of women. That same mission influences alumni and friends of the institution who in turn contribute to the university's capacity to play a transformational role in our society. By endowing professorships, alumni and friends are able to directly support the individuals who embody these ideals. Endowed professorships also allow us to retain exceptional faculty and to invest in their innovative research, as well as sustain transformational teaching. This investiture is particularly special because it bears the name of one of our most esteemed colleagues, Professor Emeritus John Colombo. It is an honor we do not take lightly, and we will utilize this gift to better serve our communities through exceptional scholarship, teaching, as well as outreach that reflect Dr. Colombo's own esteemed career. Once again, I would like to offer my congratulations to Professor Wexler on her investiture. This is a significant milestone for a faculty member, and we look forward to your continued success. I would now like to invite Dean Lamar back to introduce Professor Wexler.
Thank you so much, Vice Provost. Professor Lesley Wexler joined the University of Illinois Law Faculty in the fall of 2010, and she served as the Associate Dean for Academic Affairs from 2019 to 2021, helping me and others in the Dean's office navigate, among other things, the first and perhaps most difficult phase of COVID. Before coming to Illinois, Professor Wexler taught at the Florida State University College of Law, and prior to that, she spent 2 years at her law school alma mater, the University of Chicago Law School, as a Bigelow Fellow and lecturer in law. As Ritu suggested, Professor Wexler has broad research interests in international humanitarian law, human rights law, and sex discrimination. She specializes in those legal areas that reflect the development of anti-discrimination and humanitarian norms within domestic law, international law, social movements, and private corporations as well. She has written extensively on the Me Too movement and its relationship with the law, and has also published on the legitimacy of targeting decisions, the blood diamond trade, and the regulation of depleted uranium and landmines, along with a series of articles on human rights impact statements. Her work has drawn on case studies using Time's Up, De Beers, Walmart, and Chick-fil-A. Professor Wexler earned her bachelor's degree with honors from the University of Michigan and her JD with honors from, as I noted a moment ago, the University of Chicago Law School. While in law school, she served on the boards of both the Chicago International Law Journal and the Chicago Legal Forum. She clerked for Judge Thomas Reevely of the United States Court of Appeals for the Fifth Circuit, I believe, and Judge William Wayne Justice of the United States District Court for the Eastern District of Texas. She also worked for the Sidley Austin Brown and Wood firm, now just Sidley Austin, I guess. These names change so quickly, and Wilmer Cutler and Pickering. Lesley may be best known for her influential scholarship and the impact she has on many of the students whom she teaches and mentors. But Lesley is also, and I don't want to understate the importance of this, kind and giving friend to faculty, staff, and students alike. I think I first got to know Lesley just from sitting in her office and eating the candy that she didn't want Katie to eat too much of. That's when I really got to know Lesley for the warm and wonderful person that she is. She often presents a facade of pessimism, but I think deep down, Lesley really does believe that humanity can and will make progress as long as smart people of goodwill come together in institutions like the College of Law and are willing to see and take on the challenges and injustices in front of us. Lesley has contributed much to the College of Law as an institution, in addition to her own individual scholarly works, and I'm very grateful to her for that. So, Lesley, a distinguished scholar, an invaluable colleague, it is a privilege for me today to recognize your many accomplishments and confer on you this honor that you most clearly have earned. If you would stand, I'd like to present you with this medallion marking your investiture as the John D. Colombo Professor of Law.
Thank you all for coming today. I offer a special thank you to my parents, Michael and Rhonda, who've always encouraged me in my career, starting with a comment in the kindergarten yearbook that I wanted to be a lawyer author. I knew that I wanted to be a law professor, even if I didn't quite know what that meant yet. And neither of you ever questioned that goal. You just helped me make choices that would allow it to happen. You supported me emotionally, intellectually, financially. What an embarrassment of riches. Not only did you support me, you also showed me how to achieve my goals. You both modeled in your own lives, with your own aspirations and tremendous work ethics, how to be a professional, what it means to derive meaning and identity from your job, and how to balance the demands and pleasures of working life with the obligations and joys of family life. Thanks, of course, to my husband, Dan, who has also furthered my career in so many ways. He narrowed his own career opportunities by living in Champaign. He's been a willing, enthusiastic, and equal partner in parenting KVJ. And most directly, he has read all the papers I've ever written and argued with me about all of them in ways that make them better. He even helped me edit this talk, but if it goes too long, the fault is all mine. KVJ, thank you for being you. I am no optimist, but your indefatigable spirit gives me much hope for the future. I also want to recognize the Justice League, my trivia team, including our most far-flung member and former colleague, Justin Severe, who made his way from Florida to join us today, for keeping me entertained for 2 years of near lockdown. Others who deserve more laurels than I could possibly give in a single speech, everybody in the Dean's Suite and the IT office. You kept me well-grounded and well-advised for the 2 most challenging years of my professional life. Jackie, you always kept me well-organized and well-supported for those challenges. Dean Amar, you have my eternal gratitude for always having an open door, an open mind, and an open heart. My 2 years of associate deaning through troubles big and small, I really feel like I've served in the trenches with you, and I couldn't have asked for a better companion. Dean Venitria Patron, thank you for coming today. As an undergraduate English major, I was particularly touched that you could be here. Vice Provost Ritu Mabakela, thank you for joining us. I've had the pleasure of meeting you through various cross-campus initiatives, and I'm thrilled we have someone so actively and aggressively championing various university works with international dimensions. And I couldn't be more pleased to be the first recipient of the John D. Colombo Professorship. When I was invited to join the University of Illinois, I had already spent 4 years at Florida State. Hello, by the way, to my colleagues there who are watching by Zoom. While I felt strongly the move was a good one, I couldn't help but wonder whether my new colleagues would be as thoughtful and generous as my old ones. John Colombo put that concern to rest immediately. Every time I met with him, whether in his official position as Associate Dean or unofficial position as Welcome Wagoneer, I knew I made the right decision. And it's been affirmed again and again by my many wonderful colleagues. I am so happy to be counted among your ranks. Anyone generous or foolish enough like John to be Associate Dean, not once but twice, must really love this institution and the people in it. This named professorship is pretty compelling evidence that John, you are much loved in return. As a one-time Associate Dean myself, I can't tell you the number of times I had a challenging situation land on my desk, and my first thought was, what would Colombo do? And when imagining his steady and careful response didn't do the trick, he was always kind enough to field a phone call or email. I feel very lucky to call John Colombo not just a colleague, but also a friend. So the title of my talk is Roger and Me, the Roger, of course, being Roger Ebert. By way of background, it will surprise no one who knows me when I say that watching television and movies was my most formative childhood activity. And as a young child, I gathered with my brothers and my parents nearly every week to watch 2 shows. The first was Dallas. I think that was so my very Midwestern family could better understand the cultural and social norms of Texas, the state in which we had found ourselves. The second was At the Movies with Roger Ebert and Gene Siskel, who were about the most Midwestern people to have ever graced a television screen. From that show, I learned several lessons that strongly influenced my academic career. First, there is value and even profundity in explorations of everyday culture. There is, of course, a role for theory, sophisticated interdisciplinary methods, but there's nothing wrong with applying academic insights to the stuff of, and even in the language of, everyday life, and in using so-called low culture around us to illuminate academic insights. Hence my torts class and my academic scholarship filled with references to the Kardashians and Real Housewives. Second, some of the most interesting ideas and concepts can be found off the beaten path, by looking outside an academic field's mainstream, or as my colleague Arden Rao would put it, being an intellectual prospector. Roger Ebert frequently endorsed and shone his spotlight on foreign and independent films he believed should be, could be, would be appreciated by mainstream viewers. I view some of my work as in the same vein. It focuses on aspects of conflict and discrimination that deserve attention and exploration, but may not be at the center of the field. Hence my work on things like sub-federal integration of international treaties and amends for civilian casualties. Third, work is made better and more fun when it is collaborative. While Roger Ebert solo-authored plenty of columns at the Sun-Times, the work for which he was best known and from which he seemed to derive the most joy was his decades of televised banter with Gene Siskel. While the two often disagreed, their process of talking through their views sharpened and honed both of their insights. I've been very lucky to join a faculty chock full of potential collaborators, many of whom I've turned into sounding boards and then co-authors. Fourth, Roger Ebert taught the importance of belonging to and helping to build a community. While Ebert's work might have been marked by a sharp tone, he matured, like I did, and over time, his generosity and his inclusiveness were his true defining characteristics. He believed in and helped build a big tent in his own field. Our annual Ebert Fest, the wide-ranging, inclusive celebration of movies held here in Ebert's hometown, is a fitting testimony to the community he built among filmmakers and cinema lovers. I try to embody the same approach in my teaching and scholarship, to enjoy and learn from scholars across campus, across the world, on their own terms, rather than drawing narrow boundaries and submitting to a predetermined rubric that defines good scholarship. So for those of you who are less familiar with my work, I thought it might be helpful to identify the ideas that I keep coming back to. Many, perhaps most authors, tend to write variations on a theme. If you read a Haruki Murakami novel, chances are you'll encounter a cat, American jazz, a mysterious woman, while a lonely narrator tries to make sense of his life. I think the same is true for scholars, even scholars like me whose collected works might not initially appear to be a cohesive collection. Writing this talk helped me pinpoint those animating ideas with some precision, and for that I am very grateful. The first idea is that of mass wrongdoing. When I was in elementary school, I used to, Katie, hands over your ears, cut Sunday school at our local synagogue. Proving that academia was obviously the right path for me, I used to cut Sunday school by going to the temple library. For those of you who haven't been to a temple library, there are a few categories: kids' books about Judaism, adult fiction written by Jewish authors, and then books about Judaism, Israel, and the Holocaust. After making quick work of the children's section, I gravitated to the Holocaust offerings. Something about the enormous scale of wrongdoing, the vast numbers of those affected, and the initial reluctance of the United States to respond captivated me, and I kept consuming book after book. I remember reading about FDR's 1939 refusal to allow the German ocean liner St. Louis to dock, forcing the ship to return to Europe, where many of the 937 passengers were eventually killed by Nazis. From that, I internalized the limits on political will and lost any confidence that governments would quickly, or even inevitably, address mass atrocities. Those notions motivated my academic search for ways to prompt state action, to work around states through other actors in favor of international principles decrying mass wrongdoing such as war crimes, genocide, and crimes against humanity. The second idea, somewhat tied to the first, is the power of social movements to generate international law in new ways and new forums. By high school and college, I found a productive outlet for this concern about mass wrongdoing. I turned to competitive policy debate and learned about landmines, this small, under attention paid to object that was killing large numbers of civilians either through intentional targeting or negligence. It was obvious to me, at least, that such weapons were causing mass suffering and that existing international law was ineffectual in ending such practices. At the same time, an international movement to ban landmines emerged. I was fascinated by this unusual coalition of radical peace activists, American veterans of the Vietnam War, and celebrities like Princess Diana, who came together to generate support for a total ban. Those norm entrepreneurs rejected working within the existing legal system, recognizing that the traditional international treaty framework requirement of consensus made slow progress They forged their own path, generating their own international law framework and holding states to a much faster timetable. That interest yielded several papers about alternate ways of making international law and eventually flowed into sort of the next animating idea, accountability gaps and deficits. Coming of age as a laws of war academic in the 2000s necessarily meant that my work was shaped by the global war on terror. That is pretty much the definition of a series of accountability gaps and deficits. The war on terror pushed me to contemplate what role international law plays in armed conflict when the country I focus on and live in either doesn't join it, has idiosyncratically narrow interpretations of the treaties it does join, or maintains that such treaties are non-self-executing. This led to a series of projects on how a combination of creative domestic law and willing international allies could move the needle in the direction of international compliance, not by mandating and punishing, but by exposing gaps between the principles America espouses and its practices, and by raising the costs of remaining outside of international treaties that our allies join. The next animating impulse concerns the way law and the rhetoric of law shapes conversations about the legitimacy of actions outside of formal legal settings. Perhaps a lesser-known fact about my academic background, I did a gap year after college, coaching debate and taking graduate classes in rhetoric. The classes were a necessary part of getting a graduate stipend, but to me, they were the world's best employment perk. I could take classes, learn new things, with what I initially thought would be no consequence at all. But in ways that I didn't anticipate, those classes deeply shaped my relationship with the law and with legal scholarship. They focused my attention on the communicative aspects of law, how law can be used as a tool of naming and shaming, how law can persuade in addition to demand, how law can speak to individuals about their value or their lack thereof in society. Perhaps even more surprising to me is how those long ago classes, even now, have spurred me to think about the limits of law's communicative aspects. That, for example, the determination of what was lawful might take up all of the conversational space about the treatment of civilians in wartime, leaving often unaddressed the lawful but awful treatment of civilians. And a bit closer to home, to suggest that law's procedural and substantive tools for making criminal and civil litigation determinations would come to dominate non-legal conversations about sex discrimination, sexual harassment, assault, and rape. That law has become the language and the procedure of not just legal determinations, but also the social and moral assessment of issues, and to start thinking about how that might be problematic. While the interest in sex discrimination might seem like a departure from other ideas that I've mentioned, the more time I spend writing, the more I see it as motivated by the same fundamental insights and impulses. Just as my interest in international law has long been fueled by a sense that civilians are treated as less than, of thinking of ways to remedy how states fail to account for or value the lives of citizens, getting states to commit to practices that safeguard civilians, so too my interest in sex discrimination has long been fueled by the knowledge that people are often treated as less than on account of their sex or their gender, of thinking how to remedy ways in which employers fail to account for or value the work done by women, of getting employers to commit to creating and maintaining safer and more equitable workplaces for women and men. To circle back, such discrimination and mistreatment can also rise to the level of mass wrongdoing, as I've written about with regards to the once widespread practice of foot binding in China and the son preference exacerbated by China's one-child policy, as well as the variety of behavior encompassed by the Me Too movement. That anti-discrimination work was strengthened and sharpened when I began co-authoring with my colleagues Jennifer Robinall and Colleen Murphy. They refined my thinking about both lawful and awful behavior in the sex discrimination setting and introduced me to the tools of restorative and transitional justice. Restorative justice calls for the acknowledgement of wrongdoing, responsibility taking, harm repair, non-repetition, and the possibility of reintegration for the wrongdoer. Jen and I have worked through these ideas in both the Me Too and the armed conflict setting, two areas that have long had and continue to suffer from accountability deficits. Given the scope and scale of wrongdoing with which I am concerned, the next step in my academic journey, hosted by my colleague, Professor Colleen Murphy, was to think about the role of transitional justice. To that end, I'm going to use my remaining time to workshop a new paper that Colleen Murphy and I are working on. That's not necessarily the tradition for investitures, but this newest project is the proverbial rug that ties the room together. My interests in international atrocities, mass wrongdoing, lawful but awful behavior, social movements, accountability gaps, non-legal solutions that operate in the shadow of the law and profoundly shaped by legal discourse, and discrimination, both domestic and international. The project, Wild Transitional Justice, inquires into the role of the individual, the private institution, and corporations in enacting transitional justice. As you may have learned from my colleague Colleen's investiture, transitional justice calls for transformation of institutions, structures, norms, and practices that contribute to wrongdoing, particularly in settings of mass wrongs during conflict or repression. Initiatives include both judicial and non-judicial measures as aims to rebuild social trust, reestablish what is right from wrong, repair a fractured justice system, and rebuild a democratic and inclusive system of governance. As my co-author's work makes clear, the reason transitional as opposed to ordinary justice is required is because transitional wrongdoing differs from ordinary wrongdoing in its widespread character. Wrongdoing is a basic fact of life for members of a targeted group. The anticipation of being killed or arrested if speaking out against the government, or of being killed or subject to harm if pulled over by police for a routine traffic stop. These shape the lives of vulnerable individuals and groups. Wrongdoing, too, is collective. The victims are characteristically targeted in virtue of their membership in a particular group, such as their ethnicity during a genocidal campaign, or their membership in an opposition political party during a period of conflict. The groups are also implicated as perpetrators. It is organized and carried out by groups existing in different degrees of formality. This normalized wrongdoing is not simply a product of bad apples or bad motives of bad actors. Normalized wrongdoing points to a systemic problem for which systemic solutions are needed. The underlying rationale for responding to wrongdoing is both to deal with individual perpetrators and victims, as well as to alter the background structure of interaction that permits, incentivizes, or fails to prevent such wrongdoing. Such responses are highly political, and efforts to end impunity for normalized wrongdoing fraught and fragile. Against a background of differing understandings of the past and a shift in power, transitional justice processes can be labeled as witch hunts or political vendettas. It is thus necessary to establish the justice of the processes that occur, showing they are not to be reduced to the exercise of political power against losers, but are concerned with pursuing moral objectives like truth and reparation. Trials have to be distinguished from victors' justice and reparations from blood money. In the paradigmatic cases of transitional justice, individuals, private institutions, and corporations are thought to be the subjects of transitional justice, perpetrators and victims, participants in mass wrongdoing who need to have their wrongdoing acknowledged, subjects of wrongdoing who need to have their harms remedied, and their persons respected going forward. We think of justice as something they receive. But what Colleen and I want to explore in this project is when private actors, individuals, organizations, corporations, are initiators and implementers of transitional justice. In other words, justice is something they perform. For each kind of formal government-led transitional justice process, such as truth commissions, memorialization, and reparations, we have found what we term wild or private counterparts. While many are familiar with the South African government-led Truth and Reconciliation Commission, adopted to address the legacy of apartheid, what of the domestic Greensboro Truth Commission, established by private individuals to address the cover-up of a Klan and Nazi massacre of individuals protesting for social and economic justice? Similarly, while many states build national memorials as part of their effort to enshrine the truth, reinforce never again, and honor the victims of mass human rights abuses, so too have private organizations forged such memorials. Take, for example, the Equal Justice Initiative's National Memorial for Peace and Slavery in Montgomery, which powerfully speaks to the enduring legacy of slavery and Jim Crow practices, or the Rio Institute, memorializing the victims of and communities' participation in the international slave trade on Brazil's shores. Similarly, Evanston's decision to provide reparations to its Black residents who suffer the lingering effects of racist housing discrimination has been much lauded. But what of private newspapers choosing to investigate, document, and apologize for providing advertising space for the slave trade and for the Klan, encouraging lynching, and providing racist coverage of African Americans? Or even private individuals who investigate their own family's involvement in mass atrocities and offer reparations. Private institutions like Georgetown, who decided to offer reparations in the form of preferential admission and tuition waivers to the descendants of the 272 slaves it sold. We argue that such practices have and will continue to emerge for a variety of reasons. In some countries, such as the United States and Brazil, formal national transitional justice programs do not yet exist. In these instances, wild transitional justice might be a substitute, something that fills the hole that ought to be, but has not yet been taken up by the state. Relatedly, it might be a shove, a demand that the state engage in transitional justice by providing a model of what transitional justice might look like. Another possibility is that wild transitional justice might be a supplement. In those countries with more formal programs like South Africa or Argentina, wild transitional justice might address issues and persons not included in the nationwide project. Lastly, such endeavors might be simply indifferent to the existence or non-existence of state programs and view the matters as best handled by private actors. Take, for example, recent calls in Germany for Porsche to publicly reckon with the Nazi history of its patriarch, or calls for Brooks Brothers to acknowledge its role in American slavery by providing livery to slaveholding plantations. Governments can force such accountability. Think of Chicago's ordinance requiring all businesses vying for city contracts to search their records and disclose whether they profited from slavery. But wild endeavors might do as well, or even better. Highly motivated organizations might generate a more fulsome accountability and more creative results than a simple disclosure bill. For today, I want to focus in particular on those parts of wild transitional justice that are closest to the law, trials and punishments. So I'll begin with 4 examples of trials and punishment that might be categorized as wild transitional justice, and then move to identify the kinds of questions that might help us assess whether such instances of wild transitional justice are in fact just. The first example is those of unofficial French purge courts. After World War II, France was a transitional society facing the widespread atrocities of not only German invaders, but French collaborators that facilitated Nazis and the Vichy government. In addition to the international Nuremberg trials, the French government's national purge courts, wild efforts both preceded and accompanied official transitional justice efforts. Many private actors conducted purges designed to identify and punish collaborators. They ranged from underground court-martials and ad hoc court systems to summary executions. After liberation, resistance fighters in one town arrested several women for collaboration and took them to barbershops for head shavings. Sometimes the punishments meted out were extremely localized, as when a family effectively imprisoned a relative for 40 years after she had been accused of denouncing members of the resistance. These acts were carried out publicly. The justifications were backward-looking to avenge the wrongs perpetrated on the resistance, but also forward-looking to a new, pure, and strong France. Stronger sentences than those imposed by national purge courts were seen at the time as necessary to assure the community's reconciliation. Hair shavings were justified by allowing women to make a public acknowledgement of their transgression, but at least in theory, those women could be reintegrated as their hair grew back. The second example, Jewish honor courts, took place at the same time, but looked quite different. After some Jewish partisan groups targeted Jewish collaborators for assassination during the Holocaust, community leaders grew concerned about the spread of vigilantism and urged an opportunity to bring their cases before a proper tribunal which would mete out punishment as deserved. These honor courts, which flourished after the end of the war, aimed to achieve retribution and to respond to a deficit in the community's moral ledger. The trials were also viewed as a mechanism to further survivors' moral and ethical rehabilitation after years of brutalization and lawlessness. Like wild French purges, many supporters also emphasized the importance of purification. Jews wished to rebuild their lives by excluding those with dirty hands and by preventing them from assuming leadership roles in the community. They provided an outlet to contribute to national purification efforts. In Poland, participants viewed the honor court as a demonstration of their commitment to universal justice, reclaiming their mantle to civic virtue, and signaling their successful integration into post-war Poland. These courts evolved from the sense shared by many survivors that non-Jewish courts could not be trusted to adjudicate crimes committed by Jews against other Jews during the war, and from the strong belief that Jews not only had the right but the duty to deal with these internal matters. By working through the moral dilemmas of the choiceless choice of the recent past, the courts sought to set ethical standards for the present and the future while determining who could belong to and lead the collective in the post-war years. Suspected collaborators submitted to such proceedings because they wanted to clear their names or because of the pressure of public opinion. Some even initiated proceedings themselves to restore or clarify their position. Honor courts asked questions of whether the defendant acted how a Jewish citizen was obligated to act under the circumstances. They did not punish individuals for membership in Jewish police in ghettos or on councils who worked with Nazis or as prison functionaries in concentration camps. In fact, honor courts frequently acquitted members of the Jewish councils, leaders particularly reviled in the survivor community. The honor courts distinguished between those motivated by good intentions and feelings of responsibilities versus those that tried to save their skin through base collaboration. The courts made it their business to exact retribution, not revenge, and over time included a more reconciliatory tone. They tended to look at ethical rather than legal questions, making allowance for defenses that might go unrecognized by local courts. So for an example, the question for a Jewish policeman might not be whether he used force against a Jew in a way that would be unlawful under the new state's rule, but whether he used more force than required by the Nazis. Did he use his position on a council to benefit himself or his family, or simply to comply with German requests? This process required charges to be made in writing, the voluntary participation of the charged party, allowed for presentation of evidence under oath, authenticity of documentary evidence, and even a right of appeal. They took seriously the limits on their authority and imposed only a limited set of punishments. Reprimands, cuts or losses in social welfare benefits distributed by the Jewish community. More significant offenses were subject to lustration, the loss of active and passive voting rights, along with a ban on holding public office in the Jewish community. The ultimate punishment, rarely imposed, was banishment or exile from the community. Offer a third example from a very different setting, Peru. In the much more recent past, an internal armed conflict between the Shining Path and the government resulted in nearly 70,000 deaths, many of them committed by and perpetuated against civilians. Villagers' efforts to protect themselves and expel sympathizers resulted in significant violence among intimate enemies who shared the same communities. Many years after the conflict ended, the state initiated a truth and eventually reconciliation commission. While we're still looking for more details, anthropological work reveals extensive local processes of reconciliation occurring independently of the national efforts. Community members used a mixed retributive and restorative justice approach as Shining Path members confessed to crimes, were punished, and then allowed to rejoin the community. The last example, closer to home. During the 1967 Detroit Rebellion, a devastating period of violence between Black residents and police arising out of structural problems relating to racial segregation in housing, police brutality, and racial profiling, and extreme poverty. Police responded to a report of a sniper at the Algiers motel. During the ensuing entry and interrogation, the police killed 3 Black teenagers and aggressively interrogated and threatened others. Despite claims of self-defense on the part of the police, the medical examiner found that the dead teenagers were in non-aggressive postures and the presence of a sniper was seriously in doubt. After family members witnessed initial criminal proceedings and determined that justice would not be provided by the Michigan state courts, local civil rights activists organized a People's Tribunal. One organizer described the purpose as allowing people to evaluate the evidence for themselves. The Black community needs to see the type of justice we receive in Michigan is the same kind meted out in Mississippi. We invited the press because we want people all over the world to see what it means to be called a Black so-called American. Another participant said the tribunal recognized and created a public memory of grievances of oppressed people whose experience of injustice goes unrecognized within an interstate order that is at best reluctant to recognize the collective claims of subnational communities. The tribunal was created by a committee composed of several lawyers and various civil society groups and was modeled after actual court proceedings in many respects, including charges based on the existing Michigan felony murder statute, a jury of 12 community members, including Rosa Parks. There was a prosecution. There were subpoenas for defendants who unsurprisingly chose not to appear, but were represented by appointed counsel. 3 victims testified about what they had seen and experienced at the hotel. The jury agreed that the system was guilty, but emphatic in its judgment that the testimony of the witnesses established also the individual guilt of the police officers. The tribunal convicted several police officers and sentenced them to death, though the sentence was never carried out. Now that you have these examples, I want to turn to the question of how we might think about whether such practices of wild transitional justice are just. Luckily, my co-author and I don't have to start from scratch. We can begin with the explanations offered for why punishment is justified at all, build on this with why states may punish, and then move to specific questions raised by wild trials and wild punishments. So punishment is the intentional infliction of suffering or sanction designed to express condemnation of wrongful conduct on a wrongdoer by someone with the standing or authority to inflict it for that reason. Criminal punishment is meted out by the government in response to violations of the criminal law by a perpetrator. To explain why punishment is permissible, theories address 4 issues. They show why certain wrongs are the government's business, why the intentional infliction of suffering constitutes an appropriate method for dealing with wrongdoing by the state, how much punishment is permissible in any given case, and what due process entails for punishment to be permissible. To say a bit more about the first, why certain wrongs are the government's business, the state is often claimed to have standing in virtue of the public natures of the wrongs in question and in virtue of its impartiality and representative character. The state is thought to be neutral as an arbiter of disputes, and thus best positioned to mete out the amount of punishment retribution demands or deterrence requires. As an authorized representative of the community, the state is best positioned to vindicate and reinforce societal values, including the value of the victim and the respect to which a victim is owed, which the commission of the wrongdoing challenged and denied. Yet societies don't limit punishment to the state. In ordinary, everyday settings, we have punishment imposed by others, such as parents with respect to their children, employers with respect to their employees. When thinking about the legitimacy of such punishment, we ask similar, though not identical, questions about such actors' standing. For example, which wrongs are the business of particular non-state actors will be answered by appeal to role-related concerns. The actions of a teenage employee that are of concern to her employer are not coextensive with the actions by that same individual with respect to her parents. Similarly, why social punishment is an appropriate response to wrongdoing may, but need not track the familiar sorts of rationales for state punishment. Social punishment may, but need not match retributive, deterrent, and rehabilitative goals. The explanation of standing of particular actors to punish may appeal to the fact that the punishing authority is representative of different values in need of vindication, though the values in question and how they are threatened will be relative to the particular sort of institution in question. Especially acute concerns about social punishment arise in the context in the amount of punishment merited in any particular case and the requirements of due process or due process analogs in non-state contexts. Part of the rationale for state punishment stems from the limited capacity of private actors to adequately determine grounds for guilt, absent the due process considerations to which criminal justice systems are subject. Similarly, the ability of private actors to inflict proportional punishment is more difficult to establish. Now, I ask you to bear with me a little bit longer as I add an additional layer. What is distinctive about punishment in transitional settings? First, in such settings, there is a background of historic impunity for wrongdoing. Trials have historically formed an important component of responses to such impunity. Think of the Nuremberg and Tokyo trials post-World War II, or the International Criminal Tribunal for former Yugoslavia and for Rwanda. domestic trials have been used, such as the trial of military juntas in Argentina. Public punishment for transitional wrongdoing is done for the sake of a number of objectives. It is used to counter impunity as the de facto situation for the perpetrators of widespread wrongdoing. It holds perpetrators to account, thereby achieving justice, and to demonstrate that no individual is above the law. Trial and punishment in accordance with international standards constitutes a break with past practices in which alleged perpetrators were often disappeared or summarily executed or otherwise denied effective due process. Trials communicate that certain crimes are impermissible, no matter if ordered by an official or permitted by domestic law. The challenges are many. The ability to satisfy rule of law requirements is challenging. The actions being punished weren't always illegal at the time, generating ex post facto concerns. Some defendants were denied appeals. The existence of a legal basis for linking the actions of defendants to collective crimes has been the subject of ongoing debate, as has worries about a de facto presumption of guilt accompanying trials of this kind. Questions have also been raised about the efficacy of punishment as a tool for dealing with widespread wrongdoing. While it may be a valuable form of justice to hold a few officials accountable for their role, individual accountability may obscure the broader institutional factors that enabled, incentivized, or rewarded wrongdoing committed by many. Worries about individual culpability obscuring broader complicity and reinforcing denial of citizens of their role in facilitating or benefiting from widespread wrongdoing. The small number of defendants ever charged or convicted provides dubious grounds for trials serving as a deterrent. Finally, the issue of standing is fraught. In the case of domestic trials, standard explanations of why the state has standing to punish do not apply. Former government officials are often the perpetrators being put on trial, which means the new state may not be a neutral party with respect to the wrongs in question. In cases of international tribunals, people often ask why those countries have standing to make the wrongdoing their business. That gets us to the questions and concerns of wild transitional trials and punishment. In our minds, the most difficult, fraught, concerning wild response to widespread wrongdoing. Justifications of wild transitional punishment must explain why such treatment or deprivation constitutes a form of justice rather than vengeance. In highly emotionally charged contexts in which transitional justice is pursued, vengeance masking itself as punishment is an acute concern. We worry about wild trials' absence of well-defined norms of due process to ensure that only the guilty suffer. State transitional punishment at least operates by well-established norms. What non-state due process entails is much less defined, let alone followed. Think back to our 4 examples. How might we define what constitutes due process in those settings? Need it be the same as what a state would demand? Can it be less? If less, how much less? Jen, Colleen, and I have all thought about these questions in the domestic Me Too setting, but I look forward to broadening that scope of the inquiry with this project. There's also a concern that non-state actors might have less ability to achieve the goods that are used to explain why punishment is permissible, such as deterrence, reinforcing community values, or vindicating the value of the victim. They are not necessarily authorized to act on behalf of a community or represent and protect a community's value in the same ways the state is. But that lack of formal authority doesn't necessarily mean that non-state actors lack authority, just that it must come from a different source. On what basis are non-state actors permitted to make wrongdoing their business and assume the role of judge and punisher typically reserved for states? One of the justifications of locating the use of force in state appeal to the fact that legal subjects benefit from having the threat of use of force and punishment being removed from private action. It is against this background we can understand the fraught character of vigilante justice. Skeptics of wild transitional justice worry it is illegitimate for non-state actors to assume for themselves the functions of the state. Further worry that if given power to judge, they're more likely to abuse that power, to silence and punish unpopular views rather than mete out accountability. Especially when unconstrained by the legal requirements of due process, the ability of non-state actors to meet moral requirements for appropriate processes may be in doubt. So I'll conclude with our initial thoughts about how one might rebut this presumption against the normative desirability of wild transitional justice. 2 strategies might be adopted. The first is to show the benefit which normally obtains when the state enjoys the exclusive right to punish does not obtain in the transitional context at issue. When the state is unwilling or unable to punish serious wrongdoing, then it may be permissible for civil society to fill in the accountability gap created by the lack of state action. This was the central claim in both the Jewish honor courts and the Algiers Tribunal, for example. International law might provide some fruitful guidance as to what should count as unable or unwilling, and we look forward to further developing this idea. It is also necessary to explain why a particular non-state actor is authorized to step in to fill the void at the state level. In the case of wild transitional punishment, there may be no universal agreement as to the standing of private actors to judge wrongdoing or to fill the void. Possible grounds for showing that they are entitled to do this, authorized by consent of the community in question, the victims and perpetrators of harms, as was the case in Peru and for many Jewish honor courts. Another ground may be an explicit or even implicit delegation by the state, as was the case for at least some of the private French purges, which were strongly encouraged by the state. A second way to rebut the presumption against wild transitional justice is to show the benefit of having the state authorized to punish, my husband is timing me, I'm going a little over, of having the state authorized to punish, which does obtain, is not at risk if non-state actors step in. In this strategy, the goal is to show that the state's authority to punish and the benefits that come from punishment being restricted to state actors can be maintained even if non-state punishment occurs in certain cases. For example, if non-state punishment is meted out as a result of state delegation, there is little reason to worry about broader usurpation of the state's authority. So too, if the reason for non-state punishment is to supplement what the state is doing when the state is unable to mete out accountability effectively or as widely as was the case for Jewish honor courts and perhaps Peru as well. There's much more to say about this issue, but our time has drawn to a close. Thank you for joining me, and as Roger Ebert would say, I'll see you at the movies.
Thank you, Lesley, for those wonderfully broad and deep thoughts. I know that I will be reflecting on a lot of what you said, not just in the four settings you described, but things that maybe even closer to home here as America grapples with how best to process disagreement that sometimes turns violent. So one more time, I want us to all congratulate Lesley on her well-deserved honor today. We really look forward to your future achievements, even as we honor all that you've accomplished so far. So, congrats again. Thanks to everybody for joining us this afternoon. For those of you who are here in person, as we adjourn, I hope you can linger in the reception area in the pavilion for a little while and congratulate Lesley in person. Thank you so much.
Thank you, too.
Thank you.